I guess I set out something of a what's the word? An outline for the evening. And I figure we should just start with the most pressing one that I know everybody's talking about. Jen, and I'm going to say Psaki. It's Psaki for the rest of my life on the internet. It's Jen Psaki. Apparently it's a silent P, but I like Psaki better. So Jen Psaki's press conference and some of the, I'm calling them admissions because there's no way to downplay the degree. Some are going to call it cooperation, collaboration. I'm going to go one step further, and I'm going to say control or coercion, or coercion or control, because it sounds like they are effectively imposing control over certain aspects of Facebook. I did a vlog on it. Everybody saw what Psaki said. They are working with Facebook, doctors, federal officials, meeting with them, discussing what information to promote, trusted news sources to promote, flagging posts for Facebook, not on Facebook. And some people think that's semantics. I think that is an admission of the level of control that they are exercising over Facebook. The question now becomes, are these admissions enough to become, to cause Facebook, at least in certain circumstances, to be deemed to be state actors? Yes or no? And then we're going to get into the other criteria that might flow from this.
Not by itself, no. I mean, it's helpful evidence. It doesn't hurt, that's for sure, because as you highlighted, her use of the word for, rather than the other word term she could have chosen, and they're kind of bragging about it. They're kind of open and public about it. So I think that helps anyone bringing litigation related to it, including not only of Trump's case, but obviously Bobby Kennedy's case that's going up on appeal, and Harmeet Dillon's case, which is still the strongest in California against Twitter. So, I mean, to be a state actor, a full state actor under our current case law, they make it really hard. You basically has to be look at agency law, and are they acting as an agent of the state? And if they're not acting as an agent of the state, under, like, if this was, say, Facebook, say John Johnson said that he wanted Facebook to do something, would that constitute? Does that make Facebook, if they later do it, an agent of John Johnson? Generally, under agency law, it does not. There needs to be more than that. And so it's helpful evidence for those people bringing it, but to really bring a robust state actor challenge, what you need to allege is that they did it at the direction, at the behest and behalf of that group, or that they're occupying a traditional public field, but that's really an alternative argument. That's the Pruneyard doctrine I've talked about, that requires challenging existing federal law. State law in California supports it, but the courts have been very reluctant to apply it to big tech. So the short, it helps, but it's not determinative.
And now, so this is in the minimal amount that I've looked into U.S. case law, I saw that it's virtually not impossible, but the bar has been set extremely high for state actors. It's a public function test in that Edmondson Lugar lawsuit, where they have to be exercising what is typically a role reserved exclusively for the government. So one case was a private election where they were deemed to be state actors, but utilities, no. So providing utilities to people was not deemed to be a state actor, where cutting it off could violate constitutional rights. So the bar is high, but there's a state actor argument on the one hand. Am I wrong? The other arguments, entanglement, coercion, are those different facets of the state actor argument, or are those separate legal criteria whereby a private actor can be deemed to be a state actor for the purposes of specific conduct?
There's multiple means by which they can be considered a state actor, or another way of thinking of it, simply subject to the Constitutional's restrictions. Because, for example, in Marsh v. Alabama, which is the predecessor to the Pruneyard doctrine, there was no dispute that those were private actors who were not acting at the behest of the state. So they weren't state actors in a literal sense, but they were considered bound by the First Amendment anyway, because they were occupying a public function. Same with the Democratic Party cases. Originally, the Democratic Party got away with racial discrimination and other forms of discrimination because they said they were a private party. They were not a public state actor, though they determined who got on the ballot and who didn't. And finally, it took the court a while, but it was many decades the court bought that doctrine, or different courts did. and until the courts came back and said, no, okay, you know what, this is an election and you're performing a public function. So different aspects of entanglement, different aspects of collusion can constitute, the way I would put it is, can have the Constitution apply to that private actor's conduct. They may not literally fit the definition of a state actor, but that's irrelevant for the legal purposes that's trying to be sought after.
Okay, and so I said it in the pinned comment of the video, but does Trump amend? Well, first of all, can Trump amend his claim? And if he can, does he amend it to include this, or is it irrelevant for the purposes of that lawsuit?
Well, I'll be on
with the Facebook one, not the Twitter one.
I'll be on with Dave Rubin this week, discussing precisely that. He absolutely has to amend that complaint if it's to have any chance whatsoever. And this fact would be a helpful fact, but what he really needs to allege, he can use this as ancillary evidence, collateral evidence, corroborative evidence of changing the allegations to specifically allege that Biden and Harris and Pelosi and Fauci ordered his removal from these platforms. And this is just additional evidence that corroborates his inference of that conclusion, for which he needs discovery ultimately to document.
And I just brought up the chat. Does this admission, does it lend to succeeding beyond a motion to dismiss for the purposes of discovery to see the extent of this entanglement, coercion between the government, the feds, and Facebook?
Only if he alleges more than he's alleged so far. And even this wouldn't be enough. He needs to specifically allege that those individuals ordered the big tech platforms to remove him, and that they did so in response to those orders. Anything less will be inadequate to get past the motion to dismiss at this stage.
All right. And now, actually, I took notes tonight, people. This is how much, Robert, there we go. Look at my handwriting if anybody wants to assess my mental state. Nate, the lawyer, incidentally, who's going to be front page New York Times tomorrow in an article that everybody should read. The front page New York Times is easier to read than the digital version, which is behind a paywall. He was having an online Twitter argument with Rekieta, and Rekieta raised an argument which I'm not sure that I understand, but the chilling effect on First Amendment that what the government is doing right now with Facebook is having, such that it opens the door for some form of argument before the courts, but I'm not sure I understood the argument.
The idea is that if the state takes such action, that a private actor feels obligated to follow whatever the state is instructing it to do, then that can convert them into a state actor. Now, normally that's been very, different circumstances than present here. But in this context, the best statement would be the combination of the press secretary's statement with Biden's later statement, basically accusing Facebook of murder for not going along with his directions. So that, here you have the chief law enforcement officer of the land accusing you of murder unless you do what he tells you to do. That might be what Nick Rekieta is talking about when he talks about there's some case law out there that says if the government takes such action that it's a chilling effect, that it's basically dictating a direction, and that if you don't take that direction, the state will take adverse hostile action towards you, then that can convert a private actor into acting at the behest and behalf of the state. But it needs to be specific. So, like, for example, just because Facebook is being a state actor in one setting doesn't make it a state actor in every setting. That's where someone like Trump needs to specifically allege that as to him, they were acting at the direction of these individuals. And what they said this past week enhanced his potential claim. But he's also got to just shift up the claims. Some are state actor claims. There's different theories of state actor claims. There's different theories by which they can be bound by the First Amendment that are technically separate from the state actor claims and other common law claims. He needs to add, or that suit is dead on arrival.
Interesting comment by William Skrainsky, who will never get past this avatar. What's the difference? Biden will evoke executive privilege in discovery. Fair point.
Actually, I was going to say it's actually harder than that. If Biden won't be a party to the case, so that means you have to get through this whole other doctrine where it's very tough to subpoena the government for it when the government is not a party in the case. So they call it TUOHY principles, TUOHY. I've won several of those, but they're really, really hard. So you have to get through those before you even get close to executive privilege. So normally they don't allow you to subpoena the president unless the president's a party to the proceedings.
That is, and now can the government object? Hypothetically, they get past a motion to dismiss. There's discovery. Can the government object to Facebook or Twitter, whichever one it might be, communicating documents that include the government.
No. I mean, anything that's in Facebook's custody is not subject to governmental privilege of any kind.
Okay. Oh, and by the way, let me just bring out the beard power. I may trim the sides, people. I may trim the sides. I put up a question on Twitter. It's getting there, but man, I feel like that Kids in the Hall, for anybody who doesn't remember that particular skit where one of the kids in the hall grows a vacation beard and then he never wants to shave it. That's how this thing gives me power, it feels like. Okay, so we'll see where it goes. It's not as big of an admission as some might hope, but it's certainly, if nothing else, should be terrifying for everybody, what we see going on between big government and big tech.
Oh, no doubt. It's, I mean, you saw Glenn Greenwald. It definitely caused a lot of controversy in the court of public opinion. And so it was an interesting admission. I mean, it seemed to be bragging about what they were doing. And it does give, again, corroborative evidence to make the direct allegation. And then that's what people need to make the direct allegation. They need to say, upon information and belief, the government ordered my comment removed or me removed. That's what they need to allege to fit the state actor doctrine. And all of this evidence is strong if they say, well, did you have a factual good faith basis for it? Like the various election sanctions hearings that are taking place, but Lynn Wood and Sidney Powell and others. That's where you can say, well, look at all of these statements, including from the President of the United States, the Vice President of the United States, the Press Secretary of the United States. So, they did give a big boost to those potential cases by being so open and arrogant about it. But it shows their commitment to it, in my view, that they're going to do it, they're going to brag about it, and they expect the courts to stand by and say nothing.
Because I still think it's a massive admission, because it's not just that she said for instead of on. It was in the context of the degree and detail that she was going into, Jen Psaki, about the active efforts and the active, some will call it collaboration, but like when your boss comes into your room or your office and starts like collaborating with you, it's more like under their direction. Now, some people are going to argue that Facebook is bigger than the government. Bottom line, the government's pretty darn big. And when they come in and say, look, we're going to work with you and we're going to help you tag misinformation, promote good information, and we're going to flag posts for you. That, to me, in the context in which it was spoken, sounds like the government has effectively come in and nationalized, at the very least, Facebook for this particular behavior, which is information relating to COVID. Whether or not it turns them into imposes constitutional requirements on them for other stuff like taking down certain pages, whatever, separate argument. At the very least, it seems to have opened the door for that. But the degree of the collaboration that Jen was describing, went well beyond just the use of the word for instead of on, in my humble opinion.